Hey everybody, welcome to the Contract Teardown Show from Law Insider. I'm Mike Whalen. The Contract Teardown Show is what it sounds like. We bring on smart friends like Rachel here, and we break apart some contracts. Rachel Brenke, how are you doing today?
I'm doing well. Thank you for having me. Nothing like tearing down a contract first thing in the morning.
It's got sex appeal. It's got energy. It's exactly what the kids want these days. These darn millennials. I don't even know if millennials are kids anymore. I think they're like older now, and so we're into Gen Alphabet, whatever. But whoever is the kids these days, they love these contracts. What we're going to talk about today is, speaking of kids, expanding into other employment environments, is the Fiverr terms of service. Let me show people this real quick, Rachel. This is the Fiverr terms of service for September of 2020, which is when we're recording this. It is about 16 pages, 17 pages. We've got all kinds of terms in here and that we're going to cover. You can see in there the highlights from Rachel. So we're going to cover some of these big points. But if you guys don't know, Rachel, if you can describe what Fiverr is real quick and why this is relevant to attorneys who advise businesses.
Yeah, so when Mike invited me to come on Contract Teardown, I'm an intellectual property attorney. So I automatically went to areas where many contracts lawyers don't do a lot of IP work are falling. And it's often in like end user license agreements or things like Fiverr, which is a site where buyers can get on and hire gigs. They call it gig at Fiverr, but it's like Upwork, Freelancer, those other sites. You can get things like logos, marketing materials, even articles drafted for you and all of that. And for me as an IP attorney, I see a lot of issues on the back end when contracts attorneys haven't contemplated the intellectual property issues. And so I know this is a little different than what you guys have been doing for this series, but I figure it was kind of a good way for me to get in and stand on my IP soapbox a little bit to help y'all out.
We like a soapbox. Yeah, guys, this is if you advise anybody who's an entrepreneur or a freelancer or, somebody who does contract work, which it's 2020 and that's just going to become more and more people. We're in the middle of a pandemic right now and these employment relationships are precarious. So I think in the future of work, you're going to see a lot of this. So let's get to it. I want to start with, I love that they have registered the term gigs.
Yeah,
I
I
find
know.
that fascinating. But specifically, they point out that gigs created on Fiverr are user-generated content. There's a link on there. I assume that's because that's a defined term that's going to be covered later. What's on your mind about this section?
So for user-generated content, it's interesting, and we run into this a lot in IP, especially since I represent a lot of creatives and entrepreneurs that are creating of content and creative works, is that often sites like this can be alleviated of liability, whether it's trademark or copyright, by like these safe harbor type provisions when there's user-generated content. So one of the things that I always look at when I'm going to draft for this intermediary type site like Fiverr, where we have like a buyer and a seller, stuff's being created and rights are being transferred, is what is the responsibility of Fiverr? Here it's going to be in the vein of user-generated content. Like I said, they have a little less liability if those parties, the buyer and seller and so forth, are infringing. But it's definitely important because there's very specific requirements that allows for sites like Fiverr to be protected from or reduce liability when it comes to user-generated content, which, by the way, user-generated content is exactly what it is. It's the users are generating the content. Fiverr and those sites are not generating the content. They're just the intermediary.
Can I pretend to know something? Because I saw it on Twitter once. And so if it's on the internet, is this a Section 230 type issue where it's the difference between you're a platform versus a publisher? And because it's user generated, this is a platform, therefore we can avoid getting in trouble?
Yeah, it's funny because I have a really prominent case right now that I'm dealing with this with a site, not Fiverr, but very similar. And my entire argument is that the spirit of the copyright law specifically didn't really contemplate these intermediary sites like this. So like what you're talking about is definitely, we have to determine what is the status of the entity that is hosting platform, whatever, every circumstance is going to be different.
Right.
But I feel, and I hope, told you I was going to get on a soapbox, I hope that they eventually change it, because I feel like many sites like Fiverr, like we're going to dig into, can end up facilitating infringement and end up hurting, and it kind of smacks in the face of the spirit of intellectual property protections that we currently have.
So speaking of gigs, there's a bit in the contract about why gigs would be removed which is the punishment, right? If you post a job up there that they don't like. And one of them is it'll be removed if there's copyright infringement, trademark infringement, and violation of a third party's terms of service reported through our intellectual property claims policy, which you can find elsewhere. What about this is on your mind?
Well, first, I thought you were going to hone in on one of the very first bullet points they say is if you post a gig for like pornographic material, they're going to remove it. And I was like, where are we going with this?
Yeah, this is a job platform site, people. What are you posting on here?
We're keeping this G-rated here. As much. No, with the so this is where Fiverr is starting to set themselves up by putting the onus on the seller and buyer of these gigs, trying to put the onus on them to have the education and the requisite knowledge to not be infringing. Again, Fiverr wants to try to alleviate themselves, or any site that you're creating this sort of EULA or terms of service for, they're wanting to back themselves away from liability and put the onus on the actual users that are using the site and generating the content. What's interesting here, we're going to dig in a little bit down within the terms, is that there's a lot of conflicts. So while they are saying up front that they're putting the onus on the buyer and seller, one of the biggest issues I see as an intellectual property attorney, and I see this even with other lawyers, they don't necessarily know the nuances of IP. A creative isn't going to know the difference between copyright and trademark and be able to really provide the requisite what's the word I'm looking for? Like agreement to this and understand what Fiverr is doing. So for me, it's kind of like this two-sided. Fiverr's doing this because their legal team was like, this is what we need to do to try to get us into safe harbor protections when it comes to user-generated content. But I feel like it's failing the users in a bit. Not just saying that the users of sites should be completely free of having this knowledge, but I feel like Fiverr doesn't do enough. And there's a lot of sites this way, and this is just me because I'm protective of the creatives that I represent. I feel like there needs to be more of a connection between Fiverr and the buyer and seller to kind of educate exactly what you just said. Like they don't know the difference between these things. And so they're agreeing to terms that they really don't understand.
Right. And I mean, one of the natures of being a contractor versus having that employment relationship is you're a business owner. We're assuming that these creatives are all reading these things, much less going through and trying to understand these defined terms, which is a little difficult. On stock images, I found this one fascinating. All stock images are licensed by Getty Images. They're everywhere. Who has full ownership and copyrights to the stock images provided on Fiverr and shall be responsible for all stock images and their quality. What's up with this?
So the reason I highlighted this, because I also work with like podcasters and such. They hop on Fiverr, they get a logo created, which we'll talk about in a bit, or podcasters get podcast art, and they may not have their own photographs. They don't have good quality photographs to use. So they'll hop on Fiverr and they'll go, oh, great, I can get my podcast art done. I can submit it to Apple. I don't have to worry about photographs because Fiverr is providing these Getty Images. But this is where some of the conflicts come into play. Like you just said, those photographs are still owned by Getty Images. It's only licensed. There's conflicts later on that we're going to look at where the terms do say that any gigs that you hire as the buyer, you're supposed to have all the requisite intellectual property rights. Why this matters is I, as a podcaster, because I am one myself, I get my album art done. I want to protect that as much as possible. But under this, with using a stock image, I don't actually own that, maybe the elements that go with it, but I don't own that photograph. I only have a license of use. That will stop me from being able to do copyright registration. That will stop me from anybody else using the same image as well. You know, we want to try to have our brands to be very unique to us. And so for me, this is one of those where I was referring to earlier that creatives and entrepreneurs don't really understand a lot of the difference between ownership and licensing. For lawyers, we're like, okay, we get that, but we got to get into the nitty gritty of recognizing that when we're drafting documents for this, or we're advising people on where they're going to go and create intellectual property, me as an IP attorney, I want my clients to own their brand. I talk about this on Twitter all the time to death because it is so important, especially you talk about during the pandemic, businesses are exploding, people are trying, especially podcasting has gone up, I don't know how much percent. and they're getting this album art created and they don't actually own it, and they just become one of thousands that are using the same photographs. You don't have any protections in it. Really, what are you paying for at that point?
Podcasts are escapism for middle-aged white guys. We've all got one. Speaking of
But I'm not
logos,
really a white guy, but I have one.
everybody's got one. I saw a buddy of mine post on Facebook that said, "Who's got a podcast?" And like seriously, 100 people answered, "I've got a podcast on knitting for cats." Everybody's got one. So speaking of logo design, you've highlighted this section on the commercial use license of the logo design. Non-sub-licensable, non-exclusive, irrevocable license to use logo design embedded with the buyer's brand name for any purpose except for illegal, immoral, or defamatory purposes. For the avoidance of doubt, the seller retains all ownership rights to the logo design, and no ownership or copyrights are granted to the buyer. What about this bit?
Yeah, and what's interesting to me too is, from my understanding of Fiverr, like you mentioned, we have two different ways we can create the logo. There's the logo creator that's using Fiverr's proprietary system to create it, and then there's the logo design. So like the seller can go into their own Photoshop, whatever, and create it, and they have their own intellectual property. What you're identifying is the creation of the usage through Fiverr's system. And if you notice right there, it's not giving the buyer any rights. So what happens with that? I log on, middle of pandemic, want to get my business going because I was laid off or I don't want to go back to the office, got to get my logo created for my business. But if I'm not digging through here and reading, and this is something that actually conflicts with the summary section at the top, it talks about that the buyers will have the rights to everything that they pay for through the gigs on Fiverr. It's not true. Like if you dig into here, I get a logo created. I as the buyer, Mike, you created through me for Fiverr. I as the buyer don't have any rights to protect that. That creator, that seller can turn around and create that 1,500 times for someone else. I can't trademark it to protect it, to exclude anyone else from using the same or similar one. I can't have copyright protections on it. I don't own my brand. And like I mentioned before, this, unless you dig into this and really split the hairs of it to say, using this system versus this system, the end user, the buyer, is not going to know that they own it or not. And this just kind of trickles down even into, like, as an intellectual property attorney, I do a lot of trademark work, and I'll ask my clients, do you have the rights to this? And they'll say yes. Well, a lot of lawyers just go, okay, that's great. I'll say, where did you get it created? Because I want to know, and I have to split down into these hairs because of these terms right here. So it comes to be very convoluted, even for the buyers to be able to use it. And it actually, for what it's worth, I mean, we're tearing this apart a little bit. I don't knock their business model on this. I like the way they explain logo creation this way, logo design this way, here's the rights. I just wish it was better presented to the buyer and seller so they fully understood their rights and be able to enforce and utilize it going forward.
Well, especially when you've got very freighted terms that don't have much of a definition. So I'm looking at this confidential, top secret. Any information received from buyers should be treated as highly sensitive, top secret, and classified. I don't even know what that means.
Well, my brain automatically went to like the nuclear codes and a big red button in Washington, D.C. I'm from the D.C. area, but I'm just like highly classified. And, you know, I've had a clearance and all this stuff, but I'm just thinking, what does that even mean as the buyer or the seller? Especially me as the buyer, maybe I'm an attorney and I'm having Fiverr create something for a client of mine. I have seen that happen on there. That's a whole nother ethics discussion we can have. But what are the measures that the buyers have to protect that information? You know, it doesn't provide any guidance to the buyer, and it doesn't really tell the seller. Now, on the flip side of that, if you go over to Fiverr's privacy policy, their privacy policy is pretty good. You know, it talks about the data that they're tracking, how they're collecting it, what they're going to do with that. I wish I could see that sort of diligence in the privacy policy also here in this one section.
Yeah, I'm thinking top secret and classified. I mean, that sounds like lawyer level protected, but you know, these people, you know, they're not encrypting their emails back and forth. They're storing everything on Dropbox. I mean, they're being very casual with the information that comes out. There's a long section, I won't read this, on representing and warranting by uploading to or creating content on the Fiverr platform. You warrant that you've obtained all rights, licenses, et cetera, et cetera. What's bugging you about this section?
This, I think, is one of those measures, again, for the whole UGC safe harbor type stuff. Fiverr's trying to alleviate themselves of any liability. So it's putting the onus on the buyer or seller, because it could be either side. The buyer could be providing some of these elements that are going like into a logo or to a marketing material, or the seller is going out on the web and is procuring clip art, et cetera, and so forth to create something. So this is going for both sides, buyer and seller, saying that you have obtained all rights, license, consents, permissions, power, et cetera, which is all legalese, right? But this, again, it's only serving Fiverr. It's not serving the actual users of the site. They're not even going to understand what this means, because so many have this knowledge of, well, I can just go on Google Images, grab an image, I stick it into Fiverr, and I'm representing I have it. It's not to say that this is a bad thing. If I was Fiverr's attorney, I would probably draft it in a very similar way, looking at it from a user standpoint, because I'm going to try to be as fair and balanced when I look at drafting these sort of terms. This isn't going to do any good. And I think the reason I have a big rub here is because I see a lot of IP infringement occur from these intermediary sites like this. And it's hard because you know that they know that this stuff's happening. They're not taking measures to prevent it, and then they're hiding behind safe harbor. So I think for here is not so much that it's necessarily wrong to have it. I would love to see an advancement in how we utilize this. We can protect Fiverr and the intermediary sites, but let's help partner this somehow with some knowledge to the buyers and sellers, because then that's going to also help, in the end, benefit these intermediary sites like Fiverr, because then they're not going to be having to deal with a whole bunch of intellectual property claims, legit or otherwise.
So just for context, is this terms of service, this is the same document that both the hirer and the hiree on Fiverr receive? So when you say this doesn't protect the users, you're talking about both, right?
Both. Yeah, it's both. It's buyers and sellers are both the users on the site. They do have their own separate section on Fiverr that's kind of like a tutorial guide for buyers, for sellers. Maybe we can incorporate that with this. I didn't really see any glaring differences of the information over there. It was more of like, this is how you hire a gig. This is how you do that. So for me, this is the only thing that I have found regulating both parties.
Interesting. Ownership questions. It specifically says the buyer is granted all intellectual property rights, including but not limited to copyrights for the work delivered from the seller, and the seller waives any and all moral rights therein. What does that mean?
Yeah, so this actually is how I would love to see these sites. When, in the United States, when you hire a freelancer, whether you do it through an intermediary site or you just go on Twitter and you find someone to create a logo for you, by default, the freelancer that's a 1099 independent contractor retains all rights to whatever the intellectual property is that's created. And so for here, one of the things that I've seen in the past, I can't speak to the timing, but I've seen with Fiverr, Upwork, and larger companies, when they first came out the gate, they didn't have this sort of language, or it was very vague and loose. And so it gave a lot of questions as who owns that podcast art? Who owns that logo? So this statement by yourself, I'm happy with, to know that the buyer, when I log on to Fiverr as the buyer, all the intellectual property rights can be transferred to me. I can then go and create, trademark it. I can copyright it. I can protect my brand, etc. The problem is, and it's right before I highlighted, it says, unless clearly stated otherwise, and there's a little conflict later on. Fiverr also has this option for commercial licensing, but when the user goes onto the site, the buyer goes on to buy the gig. Again, they're probably not digging into this ownership here, or if they just scroll and see they own it all, that sounds great. But once you dig into the terms, if you select the wrong option on the gig, you're then taken out of this of owning all intellectual property rights and being put into a commercial license only, which goes back to what we talked about before. You don't own the brand then, or the buyer doesn't own the brand at that point. It just becomes very convoluted. So for me, maybe from a contract drafting standpoint, I see what they're trying to get at. Unless stated, clearly stated otherwise on the seller's gig page description, and it has good language of transferring the intellectual property ownership to the buyer, but there's so much conflicting elsewhere, like we've already talked about with the logo creator, and then also the other commercial license option. They all kind of conflict with one another.
One more, and then I'm going to ask you to tell me what the general principle is here that we can pull from this contract. The gig commercial use license, it says, by purchasing a commercial use license with your gig order, the seller grants you perpetual, exclusive, non-transferable, worldwide license to use the purchase delivery for permitted commercial uses. For the avoidance of doubt, the seller retains all ownership rights. What's this bit mean?
Yeah, so when a buyer logs on, well, let me answer that first. That sounds good,
Yeah.
except it's only a license. You don't have ownership. So that seller can go and create that logo 10 times over. You can't trademark and copyright it. So it sounds good, especially if you have a buyer that doesn't really care about owning the intellectual property, which, by the way, attorneys, if you're drafting contracts for these business owners, entrepreneurs, they need to own their intellectual property because they think they are anyway. So on the commercial licensing, the language by itself seems fine, but from a practical standpoint, when you go through Fiverr as a buyer to hire a gig, the default, if you notice, we just talked about above in the ownership section, the default is that the buyer gets it. But if you don't necessarily know and you haven't dug into this and you select commercial license because you see commercial, you're actually, the buyer's pulling themselves out of ownership and into only this license, which on its face is fine, but from a practical implementation standpoint, it doesn't really serve Fiverr, I don't think, because it's having the rights remain with the seller. It's actually not rights remaining with Fiverr at all. But it's hurting the seller in the end. I mean, I'm sorry, it's hurting the buyer in the end. The seller is retaining the rights with the commercial license, but it's hurting the buyer because if they go through and they read that summary section at the top where it says you own everything that you buy on through a gig on Fiverr, that's actually not accurate. It's once you dig into here, you see these conflicts.
There's a lot of good stuff in there about if I'm drafting, how to not have these sections conflict and make sure that you've got defined terms, defined. But if I'm advising the contract, if I'm advising the entrepreneur, the freelancer, they don't have leverage to say to Fiverr, hey, change this contract. What's the principle here? How do I advise them?
Honestly, I mean, it's digging. So here's what the hard part is, Mike. Like, we've sat here and we've identified all these different conflicts, and non-attorneys are not going to know that. So they're going to fall into that pitfall of selecting commercial license, thinking that's some sort of like commercial permission and transfer. So advising them, unfortunately, the lawyer answer would be, anytime you go get IP created, just shoot me the terms as your attorney so I can review it. But from a practically speaking, we're going to need to we have to put the onus on the buyers in these situations. They need to educate themselves. Us as attorneys have to put the information in front of them and walk them through. I mean, this is one of the things that when we have clients come to us, when we do a legal audit, part of that is the trademark and copyright aspect. We say, where did you get your stuff created? And we already have a running list internally of all these different sites and these highlights of what the conflicts and stuff are, so we can advise them. Honestly, it's almost like you cut the head off of one, you're going to get 10 million others that end up in these pitfalls. Like I said, if I was Fiverr's legal team, would I necessarily have done anything different? I think I would have just clarified it a bit more in the summary section so that it's also stronger if Fiverr ever has any sort of claim and wants to use the safe harbor type protections. From a buyer's standpoint, just got to read it. You just got to really advise your clients to dig in and understand it.
Reading contracts, the worst. Rachel, thank you. Very good information, especially about how the IP rights change with a contract that you just casually sort of push buttons through. If people want to talk to you more about the IP right transfers that come into contracts, these kinds of issues, what's the best way to reach out to you?
Yeah, I'm everywhere. Rachel Brenke, eden-law.com is my law firm. And, I'm more than happy to help you guys find resources. I have free resources you can also send to your clients if you're not an IP attorney. But I love talking IP stuff. So Twitter's the place. So check me out there.
All the cool kids do that all day. Guys, thank you for joining us in the Contract Teardown Show. Stay tuned. We'll have more of these. If you want to participate, all you have to do is email us at community@lawinsider.com. We'll have information at lawinsider.com/resources for this episode and for future episodes. We'll see you next time. Thanks again, Rachel.